ladies and gentlemen. My name is Deborah Berry, and today I would like to welcome you to the A.Carter campaign. I will be discussing some very serious issues that are currently taking place at California State Prison Corcoran SHU. This information is in regards to my husband, Mr. A.Carter, who has recently been accused of various masturbation charges, Section 54110.25. In April of 2007, Mr. Carter was currently housed at Avenal State Prison where he was accused of masturbation towards a female officer. He never knew who this officer was, and he had never received a 115 report. He was then transferred to Solano State Prison where he has sent a 602 copy to Avenal, and it never came back to him. And again, in August of 2011, he sent a second 602 copy to Avenal State Prison, and he had never received a response. During the time of this incident, I called and spoke with Associate Warden Setley. I spoke with Counselor CC2 Ms. Bryant and Counselor CC2 Ms. Martinez. On July the 6th, 2011, at Solano State Prison, Mr. Carter was accused of masturbation towards a female officer. After 2.5 months, the same officer claims she feels threatened by Mr. Carter, yet has worked AD-SEG since these allegations. She has worked the control towers, she ran showers, she brought breakfast to his cell, and she's escorted him to his hearing. On August 16th, 2011, I called and spoke with Associate Warden Kay Young. She said that the officers do this all the time and that Mr. Carter's name did not ring a bell, that she would investigate this matter and get back with me. She never did. On August 15th, 16th, and 17th, I called Captain Hutnall and left several messages with her. She's never returned any of my calls. On February the 14th, 2012, I called the Ombudsman and spoke with Sharita Walford. She said that she would make a special trip to Corcoran to investigate this matter and then get back with me and let me know what happened. However, she never did. They had given him a 6-month SHU program before he was given a 115 report. He was wrongfully placed in AD-SEG. He has witnesses who weren't able to come forth and testify on his behalf. The hearing was held telephonically with Seal Villarreal. It lasted 45 to 50 minutes long. They said that he pled guilty when he pled not guilty. There must be some indicia of reliability of the information that forms the basis for prison discipline actions, Cato versus Russian. The right to defend and present evidence is covered in the Title 15 DOM and state law. First, due process is not satisfied by a mock hearing that deprives one the right to an adequate defense, to present witnesses and evidence to refute allegations and charges. His due process rights was violated to the fullest. He was in a cell at Solano State Prison for at least 5 months around female staff members, nurses, clinicians, psychiatrists, counselors, officers, etc. At the end of it all, he gets transferred to Corcoran State Prison to do a SHU program due to the first allegations, and 8 months later he gets a new charge from someone he's never seen before. On February 25th, 2012, I was on a visit with my husband, and that's when he said that he thought that I was calling him for his visit. Instead, it was a male officer coming to confront him about this new charge. On February 26, 2012, when I returned for my next visit, that's when my husband told me that a CO Welch had given him this 115 report with a log number. And that the COs told him that the second watch sergeant had left a note for him to be moved and that a placard yellow paper be placed in his window. This has caused him to have incompatibility issues with other inmates. He then told me where they moved him. In a cell where there was glass all over the floors from an extraction of the previous inmate, pepper spray from ceiling to floor on the sinks. They did not provide him with a broom, nor did they provide him with any cleaning products, a half of a mattress, which means part of the padding was missing, and no COs told him anything. He was sneezing, choking, coughing, and gasping for air, and he was believing that he was having an anxiety attack from his earlier ordeal. He said that his neighbor from 46 cell had told him through the TV hole that the officers had just beat an inmate prior to placing him in that same cell. This is cell 4A2R47. All of this took place 3 weeks after receiving his endorsement papers to be transferred back into general population. I have been visiting Mr. Carter for about 17 years now, and throughout his incarceration, I have never heard of anything like this before, not even when he was a level 4 prisoner. It is very disturbing to know that such allegations have been brought against my husband. This has caused an emotional burden on myself, his family members, and our friends. Mr. Carter has attended groups with different females where he was left alone in rooms with these individuals with no COs present, just inmates. And he had never gotten accused by them, nor has he been written up for anything. At present, the CDCR is painting black inmates off as sexual predators out to pursue white and Mexican females, so that they would have to register as sex offenders upon their release. The overwhelming majority of 115s, DA referrals, AD-SEG, and shoe placement for indecent exposure, masturbation, overfamiliarity, sexual misconduct, etc., are black inmates by white and Mexican staff. Most of these allegations are manipulated by white and Mexican male COs. They had threatened to dispose of his property instead of sending his property home. His due process rights was violated by giving him an illegal shoe program. The law says that the state must afford procedural protections against arbitrary state action. Due process is procedural and substantive in law. It is also mandatory in nature and in construction. U.S. Constitution Amendment 5th and 14th, where there is severe impairment of residence of liberty, this impairment triggers requirement for due process safeguards, USCA 5 and 14. This is a state-imposed protected right stemming from rules, statutes, and regulations, Penal Codes Department's Operations Manual, and CCR Title 15 rules. Arbitrary and capricious conduct constitutes malfeasance by the reported employee, the investigative employee, senior hearing officer, and the classification committee for assessing an illegal shoe term, causing liberty entrance violations, good time credit, forfeiture, and property loss. All these individuals were acting under state law and color of authority. The reporting employee falsified a report, the investigative employee, McCraw, and the senior hearing officer, Lieutenant Ferguson, aided and abetted this officer and report by deceptive means, violating state and federal law. This is willful and malicious in nature. Yes, Mr. Carter is innocent. It is not in his character to disrespect any staff or staff members. He is struggling to regain his freedom. This is a letter that my husband has written the Director of Corrections on December the 2nd of 2011. I am requesting that I be placed in a cell living level 2 prison to endure my right and ability to reside in a non-threatening situation that does not affect female staff members, as well as accords me the opportunity to seek my liberty entrance and parole, because it would clearly deem justice all around if I was removed from the environment of dorm living, so that the slightest chance of this situation happening again in the future is curtailed and or minimized. I am pleading with the system to place me in a cell living environment as a life or term inmate compatible and shields me from future complaints and CDCR 115 reports. I am asking the CDCR to protect me in the prevention of accusations and guilt by previous accounts. By law, I am entitled to be free of cruel and unusual punishment. I am entitled to equal protection under the Constitution and have a right to pursue my liberty entrance. I am not asking for special privileges, just fundamental penological goals of corrections and rehabilitation. With 31 years of incarceration, the need to pursue my freedom is imperative, and residing in dormitory is detrimental to that objective. Because any female staff can accuse me of the same activity in which I would continue to be precluded from attaining my freedom at the behest of the CDCR. Any future accusation could not all but doom me of my chances of paroling. In order to secure that right, I must be given general relief protection from arbitrary and capricious write-ups and assistance from you by placing me in cell living. This request is beneficial to everyone involved and provides the right means by which no future occurrences can manifest. This is something that the administration should welcome. On March 24, 2012, I was visiting Mr. Carter, and he had brought some very disturbing information to my attention. As you know from my previous letters that on February 26, 2012, Mr. Carter was accused of masturbation towards an officer while currently serving a SHU term. These accusations took place 3 weeks after he had received his endorsement papers to be transferred back into general population. He has observed while in the shoe that other inmate stories are very similar to his, such as masturbation and an assault on staff, and that CO Lopez has a history of lying and writing false reports on black inmates. While exiting or entering their cells and or escorting an inmate to and or from a visit, a CO will bump into the inmate and then will accuse the inmate for an assault on staff. At that point, the CO will then go and write a false 115 report on the inmate, which will then cause the inmate to have done a longer shoe turn. I am really concerned for Mr. Carter's safety because of these allegations that has recently been brought against him. I am concerned as to what will they do next. This has caused an emotional burden on myself psychologically, mentally, and emotionally. Because of these allegations, Mr. Carter has been written up and given a 115 due to a new trumped-up charge, which had supposedly had taken place before his visit on February 25, 2012, from a CO by the name of Lopez, a CO that came to his cell to let him know that he had a visit. And then minutes later, that's when CO Welch came to confront him about this new charge. Mr. Carter said that he and CO Welch had a talk man-to-man, such as, do I look like I have an erection? Do I look like I'm naked? And do I look like I can do all of this minutes before my visit? And CO Welch said, well, that's what she said, and then walked away. Here's what CO Lopez said in her statement. That she yelled at Mr. Carter to stop it and to stop it now, that he was naked and he wouldn't stop and ran to the back of the cell. Mr. Carter is a very respectful individual that does not disrespect any staff or staff members. He does not commit such lascivious lewd acts of any kind. I ask that a full and fair investigation take place regarding the accusers and the California Department of Corrections and Rehabilitation. If you have a loved one in the California state prison system that has recently been falsely accused of a masturbation charge or a lascivious lewd act or an assault on staff, please write us. We want to hear from you at Deborah Berry, General Delivery, Modesto, California, 95350. That's Deborah Berry, General Delivery, Modesto, California, 95350. Sign our petition, ladies and gentlemen. We need your signature and say what you got to say. Thank you very much, ladies and gentlemen, for listening, and have a wonderful day. Goodbye.